Let's talk first of all about start with your family, and particularly Kirsten, who I think you were married in 1961.
We were married in 1961. It's now been 55 years, and she's more wonderful than ever. She's a Swedish graduate of the Fort Dodge High School, 1956, was an American Field Service exchange student, and is now the grandmother of 9 and mother of 4 sons.
Well, we'll talk about those in a bit, but I want to visit a little bit more about how you met Kirsten, because she was at the University of Iowa with you.
She was at the University of Iowa. One of my best friends was Craig Beck, whose father had been a federal judge in South Dakota, Axel Beck. And Craig's father was from Sweden, and he fixed me up with this Swedish exchange student. And even though it was something like her 4th date, the day we had a blind date, we, from then on, knew that our future was fixed.
But she, your blind date wasn't long before she left to return to Sweden.
About a month. And during that month, however, I did drive her up to Sioux City and to Odebolt to visit my grandmother, where I had worked on the farm. And she fell in love with my grandmother, who also was from Sweden.
And did your grandmother approve?
She didn't voice any disapproval.
But so you took her to see your family?
Took her to see the family, and she was just as personable as ever.
And then she left and returned to Sweden.
She left to return to Sweden for 1 year, during which she spent 6 months as a Red Cross nursing student and then a nurse for the military in Sweden, and followed up later in her life with a career as a registered nurse.
Now, she was there and you were here. How did you propose to her?
We spent a year correspondence by letter. I have the entire set of letters, and it's why I think letter writing is a lost art. And even though they're a little bit overly romanticized, it's wonderful because they are an ongoing day, or at least week by week, diary of what was going on in our lives when we weren't together. And then we were married in Sweden a year later.
I want to back up just a little bit. I started maybe a little too early, but you were raised in
Sioux City, Sioux City Central High School graduate, and went to Harvard and University of Iowa Law School, which was the best 3 years of my life before marriage.
You played basketball for Harvard, didn't you?
Played basketball. As a freshman, I was the captain of the basketball team, and it gives you an idea of the quality of basketball at Harvard, that I had never gotten a letter in high school. But when I went to Harvard, I was the captain of the freshman team. Freshmen couldn't play varsity, and then I was a starter later on.
How did the team do? Pretty good?
My senior year, we were 19-5, I think, and I'd go back and play in the annual alumni games when they are always amazed that I'm 50 or 60 or 70. I haven't been there as an 80-year-old yet, but I can still run and jump. And it was great fun because I was always into sports, but never a letter winner until I went to college.
I want to digress just a little bit about your more extended family. You have 3 siblings?
I have 2 sisters and a brother. My oldest sister is 10 years older, my brother 8 years older, and my other sister 5 years older.
So you're the youngest?
I have always been.
And still are. They're all healthy?
They're all alive and well, 90 and down.
Your brother had an interesting career.
He was very interested in the Foreign Service. After 2 years at Morningside College in Sioux City, where my folks had both gone, and my wife is a graduate of Moines, so are my sister, but my brother graduated Moines and got a graduate degree at Columbia University, as did my older sister. Hers in English, his in Foreign Service. While he was at Columbia, the president of Columbia, that's a nice question, was Dwight D. Eisenhower.
Mm-hmm.
And he was in the international arena. From that day on, my brother started with a career as working in embassies in Baghdad, in England, then in Oman and Amman, Jordan, and all over the Middle East, and became fluent in Arabic. And he, unusual for an Iowan, was strictly an international diplomat.
He rose fairly high, though, in the Foreign Service, didn't he? Didn't he become an ambassador?
He became ambassador in 3 countries. Oman, which has a capital of Muscat, United Arab Emirates, and for a brief time in Bahrain. And he was appointed ambassador initially by President Nixon.
Really? Oh.
And a funny question came up. One of the senators at the Judiciary Committee hearing said, "I remember your brother when he was being confirmed to be ambassador." He said, do you also speak fluent Arabic?
Who had that memory? That's remarkable.
It was, who is the longtime senator from Vermont?
Currently? Not Senator Leahy.
Yeah, Patrick Leahy.
Really? I'll be darned. Well, your brother made quite an impression.
Well, I think he had done a little study to see who's this guy, because at that time he was the chair of the Judiciary Committee.
Why did you decide to go to law school?
My father was in the business of real estate and investing, mostly insurance investment. A firm in Sioux City, Iowa, there he had gone to right after graduating from Morningside College. And my father thought it would be great to have a lawyer in the firm as a realtor and insurance broker. And that's really why I started law school. And then about a year and a half into law school, I realized that I really wanted to be a trial lawyer. And away I went.
In those days, was it hard to get into law school?
It was so easy that I didn't apply until something like June. And as I recall, they accepted anyone who had been a graduate of undergraduate school, no matter where. But only about 2 out of 3 graduated from law school.
Was it a tougher curriculum
than today?
Maybe today, or maybe hard to compare.
It was very general. We had everything from not soup to nuts, but certainly contracts to conflicts to examination of abstracts of title. And I could have gone out and practiced in a small town in Iowa with a general practice.
Who, in your legal studies, was most influential at Iowa?
Well, certainly Dean Ladd, because he taught evidence, and I later became something of a self-styled expert on evidence issues. I thought Frank Kennedy was a wonderful teacher. He later went to the University of Michigan as their teacher of conflicts of law, but he also taught constitutional law, and he was just terrific at the Socratic method of not telling you anything, but asking the questions that brought out what you didn't know and what you did.
But after law school, then, you're thinking of going to work for your father.
Well, no. By the time I was a senior in law school, my father had been alerted that I was not going to be a real estate salesperson or developer. I was going to be trying to practice law, and I had met two lawyers that I had a great deal of respect for, Bernard Marks and Wiley Maine, later Congressman Maine. And I went into their firm, and it was called Shaw, Marshall, Maine, Marks of Azinas in Sioux City, and it was a firm of 10 people, which was huge for those days. Largest firm in Sioux City.
And you were with them for nearly 20 years.
19.
Well, you graduated from law school in 61?
61.
And went to the firm?
Went into the firm working with Wiley Maine after getting married in Sweden. And then I had only been with the firm for about 3 months, and I went into the U.S. Army Reserve for 6 months active duty, so I wouldn't be drafted for 2 years.
So you were in 6 months active duty, and then how long in the reserves?
5.5 years of reserves, and achieved the great goal that I had, which was be a buck sergeant.
What did they have you doing?
3 stripes.
Where did you go in the Army, and what did they have you do?
I was infantry all the way until I got into a unit in Sioux City that changed from being infantry to being terminal service. We loaded and unloaded ships at the docks. And the reason they did that, because at that time we were worried that the unions on both coasts, if there were a war, they would go on strike because they would not want to battle the communists, because the unions were pretty much communist dominated. So they wanted farm boys from Iowa, and I was in a unit with mostly farm boys, and that's why I was a loader of ships. It's called hatch foreman or winch operator.
Was your law firm pleased to give you time off for?
They had no choice, but they knew from the start that I would have that 6 years of reserve duty, and it was right in Sioux City. And each summer, it was 2 weeks of camp, and all they gave me was 2 weeks of vacation anyway, so my vacation was, for 6 years, Army Reserve camp. And we went interesting places to load and unload ships. Fort Eustis, Virginia, Fort Lewis, Washington, Camp Theodore, Mississippi, down by Mobile. How's that for excitement?
I can't imagine a more exciting place.
And we would drive to most of those places and get paid something like 3 cents a mile.
Well, do you keep up with any of your Army friends over the years, or they?
I had Army friends, but the only one that I knew well was Bill Rawlings, who was the company commander of the company that signed me up before I got drafted, and that was Justice Rawlings' son, and he's, I think, still practicing in Sioux City in a firm of Kindig and Beebe in Sioux City, Iowa. Good guy, and I had known him from the grade school where we both went to school.
Well, when you first went to your law firm, what did you see yourself doing?
When I first went in, I didn't know. I had taken a full range of a variety of subjects for being a lawyer, and they had said we start everybody out doing basically adjusting work for insurance companies, and you'll have to do some interviews of people, and we'll get you into estate planning and the whole works. But soon I became a specialist in getting ready for trials and even trying cases, because it didn't take long to realize that they wanted me to work with Wiley Maine who was both a trial lawyer and also interested in becoming a politician, and they figured one day he would leave and they'd need a replacement, and that's exactly what happened.
And did your litigation or your trial work pick up after that?
The firm had an excellent clientele. Just about everybody worked at rainmaking, and so I never had to really go out and try to get clients. We had a number of insurance clients. We also picked up personal injury work, especially through subrogation claims that insurance companies would turn over. And there were basically 2 large firms and then a number of smaller firms in Sioux City. The other larger one, which probably is now known as, well, I don't know what it's now known as, but at that time it was Harper Gleistein, and they had about the same number of lawyers we had, which was basically 10. And their principal trial lawyers were John Gleistein, Dunk Harper, and then later Marv Heidman, who joined the firm about the same time I joined the Shull Marshall firm.
You also did some labor work, didn't you?
I did a lot of labor law work because Jesse Marshall, who is the Marshal of Marshall on Titles, also wanted me to be a specialist in labor law because he was tired of negotiating with one of the state's great labor specialists, Harry Smith, who has handled labor cases all over the state and a lot of political matters for years.
So you did a lot of labor negotiations?
I did a lot of negotiation, a lot of arbitrations, and trying to keep clients who come to me from being unionized. Sioux City was quite an active union city, as was Cedar Rapids and as was Des Moines.
Well, all during this time, you and Kirsten are starting to have some children, right?
Yes. Born in 62, 63, 66, and 70.
62. Who was born then?
Carl, who is now a lawyer here in town, handling juvenile primarily, working for the public defender.
And
the next boy is Eric, who is now in Nashville, Tennessee, and does computerized fingerprinting. Third son, Thomas, is a lawyer with the firm that used to be called Moyer Bergman. Now it's called Simmons Pride Moyer Bergman, and he's doing much the same kind of things I have done as a lawyer. And the fourth son, Aaron, whom you know, is a musician.
In 2003, when last year on the video, the grandchild count was 7.
Now it's 9, and I think that's the end of the line. But 8 granddaughters, 1 grandson, and they are the light of our lives.
Well, let's talk about becoming your interest in becoming a judge. How did that come about?
I was always fascinated with Supreme Court justices and studied a lot about judges. I had met judges in Sioux City. I knew Morris Rawlings, for instance, who had been a trial judge and then was on the Iowa Supreme Court. So I always thought that would be interesting work, but I didn't know how you studied to be a judge. It's not like in Sweden, where if you want to be a judge, you start out going to school to be judge. I had a picture on my wall of Learned Hand, the great Second Circuit judge, Court of Appeals judge, and the wall in Sioux City. And people say, "Why do you have that picture up?" I said, "Well, I like him. If I'm ever a judge, I want to be learned." He was the leading light of the non-Supreme Court judges of America. And then I didn't give it much thought until in the law firm, there were, and I suppose it's typical, controversies about who should be paid how much. And once I became a partner, I got into some rather nasty arguments with my partners about who was being underpaid and overpaid. And finally, I had it up to here, and so I said to my children, and this is on the earlier tape, we're going to have a family council because I'm interested in getting a job in Sioux City as a trial judge because there are 2 openings of the 4 positions. And I'm not going to try for it unless you all agree. And they said, well, what it would be bad about that? And I said, because my pay would be 1/3 what it has been the last few years. But I said, it's only going to affect your inheritance. It's not going to affect your college. You're already lined up to go to school.
And the vote was?
4-0.
To
Kirsten had agreed that we could submit it to the children.
As I understand it, there were 2 openings at the same time. One was David Blair.
One was David Blair, who later became very active in arbitration as an arbitrator, and the other was George Davis, who had been a long-time trial lawyer and then a judge. So 2 out of the 4 positions were open. There were 4 persons nominated. The Governor Ray picked 2, and that was Branco, Dick Branco from Holstein, Iowa, who was from the, let's see, the 3rd district had 6 counties, and he was out in the county, and generally they tried to maintain 2 positions out in the county and 2 in Sioux City.
So you were appointed for Sioux City.
I was appointed, well, I had to go to all the counties, but for instance, Dick Branco would take all of his county and most of those outlying counties.
When did you go on the bench?
1981.
And then you would have interviewed with Governor Ray for that?
Bob Ray, and Vern Lawyer made the pick. He was Bob Ray's former partner.
And picked you.
I had a rather lengthy and cantankerous interview with Vern Lawyer. At the end of it, he said, I'm not sure. And then I got a call from a friend, I won't name that friend. He said, what you really ought to do is have another meeting with Vern Lawyer because I don't think he liked you. So that lawyer in Cedar Rapids said, get over here. So I drove all the way to from Sioux City to Cedar Rapids to sit down at dinner with my friend, and Vern Lawyer was there. And I guess I softened what had been bad approach. And so Vern gave me a thumbs up, I guess. He never told me that, although when I was finally picked for the Supreme Court on the second go-around of the Supreme Court, I called Vern Lawyer and he said, I've retired undefeated, which suggested to me that he'd never had a judge picked that wasn't his choice. And I've heard from others that Vern broadcast that widely.
Well, you were not on the district bench too long before there was a vacancy on the Supreme Court.
There was a vacancy and I wasn't picked, and then about 6 months later, I was. The first vacancy, as I recall, was as I don't recall, was Bob Albee.
Okay.
And Jim Carter was picked to replace Bob Albee. And then I was picked to replace Clay LeGrand from Davenport.
And you went on the Supreme Court in?
83.
Right. And it wasn't too long before there was a vacancy in this court, I think, right?
It was 87.
How did you become interested in the federal bench?
Well, I'm going to drop a name. I hope nobody will be unhappy, but Nick Critelli from Des Moines and I were good friends. I had moved to Des Moines when I went on the Iowa Supreme Court, and I was working closely with Ward Reynoldson. And then he appointed me as the chair of the Committee on Rules of Evidence, and we converted the federal rules of evidence into Iowa rules. And I worked closely with Nick Critelli. In fact, when I went on Supreme Court, Nick replaced me as the chair of that committee. And he called me and said, we hear that Bill Stewart is going to retire. And we're looking around for people who we want to put on, as though Nick was the picker. And why don't you put your name in? And I said, I've only been on the Supreme Court a short time. I enjoy the work. I really want to be in that kind of a constant move role. And Nick said, well, think about it. And after that, I was told by several people who need to be mentioned, but they were active in politics. I never had been. They said, you should interview Chuck Grassley because he's going to make the pick. And I actually heard that I'd make more money as a federal judge, and I had really wanted to be back on the trial bench. Iowa Supreme Court was very interesting and greatly collegial, but I wanted to be back on the trial bench where I'd see people every day. So I talked to Senator Grassley, got along well with him, and then I was one of the people not picked. A committee of some kind put up 3 names. They were Richard Turner, the U.S. Attorney, or was he Iowa Attorney General? I'm not sure. I guess he had been both. And Jim Carter, who was my colleague on the Iowa Supreme Court, and Ron Longstaff, who later became my very close friend and colleague as a district judge here. He was then a magistrate judge. He had been put up for district judge at least twice before. But those 3 names went to Grassley, and then Richard Turner suddenly died, and Jim Carter decided he didn't want to be a federal judge and changed his mind and withdrew. But I still have a copy of the wonderful letter he wrote to Senator Grassley. He said, you might consider my colleague, Wolle, because I'm not interested in moving to Des Moines as a Southern District judge. And so I was then put into a new group of 3, Wiley Pillars from Clinton, who everybody thought would be the likely Southern District judge, and Rosemary Sackett and I. But I was picked.
And took office in?
87.
In 87.
Got a phone call from the president.
Tell me about that.
Well, I had heard that President Reagan liked to call the judges he had decided to pick. and I was alerted that I was shortlisted, and then that I would get a call, and then I received the call when I was in the Iowa Supreme Court building, and Nancy Ryan, who was the Chief Justice Rattleson's secretary,
And now Judge Rose's.
now Judge
assistant.
Rose was mine for many years, she ran in and said, "It's the president on the phone." And I said, "Great." And so I picked up the phone and somebody said, "Wait a few seconds and it will be President Reagan." And it was. And I quickly put a tape recording device on my earphone so I could tape record the conversation. I listened to it many times.
What did he say?
He said, he didn't know who he was talking to first. He said, and so unusual for a phone call where the first person talks who is the one that is receiving the call, not making the call. I said, President Reagan, so good of you to call. This is Justice Charles Wolle in Des Moines, Iowa. He said, oh yeah, would you like to be a federal judge? And at that point, I wish I'd said, well, I understand you're looking for somebody for the U.S. Supreme Court, and that same day, Robert Bork got the call, but he didn't get confirmed. But that's what happened, and of course, it was primarily because Charles Grassley decided that he wanted me at that point, and I certainly didn't say no because it was a nice pay raise.
So you start in '87. You're down here. You're on the first floor. That's your...
August of '87, I took the same seat that Bill Stewart had had. He was overjoyed because he had been trying to leave for some time, but the selection had gone slowly because of their committee first coming up with different names, then Richard Turner up and died, so forth. So I started, and I knew I was into it strong when the first week after I started, I had 3 criminal cases on the docket, and so I picked 3 juries that first Monday, and then I tried them sequentially through the rest of the week and got verdicts in all 3 cases. And somebody said that was the first time anybody'd ever seen a judge start by picking 3 juries. I don't know if they still do that or not.
I don't.
And we were immersed in criminal cases at that time. It was just Harold Viator and myself in the Southern District, and then Don O'Brien, who was really Northern District more than Southern District, and really covered Council Bluffs primarily.
He had a dual position.
Right, he had the swing position.
He succeeded Judge Hanson, I think,
He
in
did.
the dual position. And he took senior status. Somehow we got an extra judge.
Later, when I went on, there were just Viator and myself plus a half position, and then I think the half position became a full position here, and that was Bob Pratt.
Or was it, I think it might have been Longstaff.
It may have been Ron Longstaff. In any event, yes, because when I was chief, it was Hal Viator and Ron Longstaff as the 2 with me. And I don't know exactly when that change occurred. It must have been when the Northern District got a second full-time. And that would have been Don O'Brien and Nick McManus, I think, before he went senior.
I think Judge Longstaff came in about 1991. Does that sound accurate?
I don't know.
Okay. But once he was appointed, then it was you, Judge Viator, Judge Longstaff. Judge Viator was the chief judge.
Correct.
And then you succeeded.
Then I succeeded him, and Ron succeeded me, and then Bob Pratt succeeded Hal Viator.
Right. Now, I came in 1994. I mean, I only mention that for a point of reference because one of the things I noticed was we'd have judges meetings. Remember those when you were the chief judge?
I went to a meeting at the Judicial Center in Washington, D.C., where they brought in all of the persons about to become new chief judges. Every 7 years they would change chief judges. And I went to that meeting, and I was very impressed with a court administrator from a southern state. It may have been Virginia. It may have been North Carolina. But that he was an administrator who thought that every chief judge should have at least monthly meetings with other judges and with the clerk of court, and even extend it to bankruptcy. And I thought it was a great idea, and I tried it. Hal Viator didn't agree with me, but as you may recall, Hal and I would have fun with each other about what we were trying to do, but would never yield.
What I recall is you'd call the meeting to order, and then he'd make a motion to adjourn.
That would be happening routinely. And Hal and I were too much alike to get along.
We kind of needled each other.
Yes.
In those meetings.
But not deep.
No, good-natured.
Hal's my idea of a judge's judge. He always did what he was firmly committed was the right thing. And I think that's the tradition here from Bill Stewart to Bill Hanson and on through, and hopefully to today, because you don't want a judge who is acting in a way that is contrary to that judge's belief and conscience, and political should have very little to do with it.
And I think it did have little to do with it.
It did. There have always been questions from the lawyer who loses about whether it wasn't because of the political. I've never seen that really make a difference, except maybe in sentencing of persons where there was discretion. Of course, at the court, now the Galt case changed that to give district judges more discretion. When I first became a district judge here in the Southern District, the guidelines were set in stone. And so there was very little discretion for the judge as to what the sentence would be. And then Bob Pratt, Judge Pratt, entered a decision that decided the guidelines shouldn't have to be followed and set in stone, and the U.S. Supreme Court said, right. That's, is it the Gall or
the Gall case?
Yeah.
It's his case. Yeah.
It made a difference. But when I was first a trial judge, once the jury decided or there was a plea, the sentence was, you had to file the federal sentencing guidelines.
Since becoming a senior judge, you haven't continued to try criminal cases, isn't that correct?
I have not done so since 2002.
But, so while you were, the Gall case I think was, I'm going to guess 2005 or thereabouts. So while you were trying criminal cases, you pretty much had to follow the guidelines unless there was a really good reason not
We
to.
thought we had to, and then the U.S. Supreme Court said so. And I found it comforting in that I agreed with the idea that there shouldn't be great disparity among persons doing the same criminal acts for the sentence they would receive. I saw much disparity in the states, in the trial practice, the federal sentencing guidelines were intended to take out the disparity, and I think they have, primarily. You have to give very good reasons not to follow the guidelines, or rely on the lawyers to negotiate fair plea sentence as part of the plea agreement.
Now, every discussion like this has to have a question like this I'm about to ask you. In the time that you were an active judge, until you took senior status in 2002, I think, right?
Correct.
Are there any cases that really stand out that come to mind?
Yes.
Can you tell me about those, that or those?
Principally, I would say it was my involvement with asbestos cases, asbestosis, and other diseases arising from the large use of asbestos in many different places. And there was a very large class action case, but it was individual plaintiffs, persons working at the Firestone and the Pirelli plants here in Des Moines. I think at that time they had different names than that, but now they are Bridgestone and Pirelli. And there were, I think, over 100 plaintiffs who had claims of disease resulting from their working around the asbestos products. In order to organize those cases, I worked with judges from 9 other states to try to put them all into the inter-circuit assignment committee, but it didn't work early on. And with all these cases, I think we had 100 here, and then there were a lot of state trials because it wasn't all federal, it was state. I tried to work as best I could with Magistrate Judge Celeste Bremer, who is great at organizing things. We put together meetings. We even had a meeting at, I think it was the Fort Des Moines Hotel here in Des Moines. We brought all the lawyers for plaintiffs and defendants together, state and federal cases, tried to work out large settlement. And when they didn't go away, those cases, and when they went to some individual results that were very disparate, maybe 4 out of 5 would lose, but the 5th would have a huge judgment. We didn't like that outcome. I worked with the lawyers, and these were lawyers including Lex Hawkins, but other lawyers from other states, representing both plaintiffs and defendants. And I had 8 slots for trial. And I had each side, the lawyers on each side, pick which 4 plaintiffs they wanted and which 4 defendants. No. Defense counsel picked 4 plaintiffs. Plaintiff's counsel picked 4 plaintiffs. That way we thought we could get a cross-section, an array of how the juries would view these cases. And we were hoping for a showing that depending on what was the extent of your ailment, you'd get an appropriate amount. Well, unfortunately, all the cases went to the jury, and the jury returned verdicts for the defendants in all cases. So we didn't get the selection done, but the theory was good, and eventually all of those cases were resolved by settlement. And nationwide, finally, the Committee on Inter-Circuit Assignments picked up all of the cases from all the courts, and eventually there were mass settlements across the country.
Weren't there at one point in this district alone over 1,000 cases?
I think there were. But a lot of them, no, not just the district court. I think that would include the Iowa cases. But I worked with the lawyers in Cedar Rapids and Sioux City as well as Des Moines in bringing together lawyers who would sort out how we could approach this. And it was their idea that we would take a selection of plaintiffs to get an idea of what cases were worth. But of course, there were trials going on all over the country, individual cases, and so lawyers who were specialized got a sense of what each of the jury verdicts might be. Ron Motley was a lawyer from South Carolina who testified before the Senate Judiciary Committee and told the Senate Judiciary Committee why the Congress should try to enact legislation to settle these cases. And I was in there with Bob Parker from Texas and judges from other states. We all gave brief testimony, and I still remember there were figures about the billions of dollars that had been spent on the asbestos litigation and how little of it had gotten to the injured parties. And so it was a large project, and it resulted in there being a committee. It was called the Mass Tort Committee of state and federal judges who met annually to try to sort all this out. And now I think most of the asbestos cases are gone. But I notice on television there's still advertising by lawyers in some places that are trying to get more money for asbestos victims. And as an aside, if there's one thing I dislike intensely, it's lawyer advertising. I don't think persons should be hiring lawyers because they see them on the tube. And when I was on the Iowa Supreme Court, we entered a decision that did not permit lawyer advertising. I don't know how much is going on these days.
I think the rules have changed somewhat.
Well, the U.S. Supreme Court said lawyers had a right under the First Amendment to do commercial advertising, such as television.
You live in Nevada now.
In Nevada, there's great deal of advertising and crazy ads.
Well, going back to other, do any other cases stand out that we ought to talk about in your?
Well, I had one very interesting criminal case involving a man named McKee, who was the administrative head of the AFSCME union here in Iowa. He had a big battle with Governor Bradstead over pay for AFSC, AFSCME employees, and he was charged by the U.S. Attorney with taking funds improperly from union monies. And it went to the jury, and the jury found him guilty. And then I had to sentence him. He was an enemy of Governor Branstad at the time, and I knew it was going to get a lot of publicity, and the governor assisted in that by saying how awful that the unions were run by crooks. But that was, Don McKee was, he was using money to buy flowers for his girlfriend, as I recall. And he was married to someone else. So many other cases. Some of the most interesting cases were in New York.
Well, I thought we'd talk about that next, because you volunteered to go out to Brooklyn, the Eastern District of New York, I think.
I did for a number of years.
Is it before you were on senior status, or
it was
after?
Before. It was when our caseload had dropped somewhat. The asbestos cases had faded away, and I was on a committee of the Judicial Conference of the United States, Magistrate Judge Committee, which was great, interesting work, because I've always believed wholeheartedly in what people like all magistrate judges all across the country do. And in that work, Tom Platt was the chief judge and a member of that committee in the Eastern District of New York, and he complained that I had many fewer cases than he did, and I said, well, bring me out and I'll help you. And he did, and for each August after that, when the judges in the Eastern District tended to go out to the Hamptons or other places for the summer, I would go and use their courtroom, and they'd give me their 30 oldest cases, and I'd have 15-minute in-person conversations. They were generally very old civil cases. I didn't like doing criminal cases there because I wasn't sure of just what their approach to sentencing was. But that was extremely interesting work, especially because you're working with totally diverse ethnic groups of jurors.
Well, how did you get those stale cases?
I got the stale cases because I would say, give me your 30 oldest cases, and a few of the judges had very old cases, and they were delighted to turn them over to somebody, and I would take them and have a 15-minute telephone conference, or in-person conference in the courtroom in Brooklyn. For a week, I would do those. They were like settlement conference, but they were really get ready for trial conferences. And I remember my favorite line was, there's only one motion I will not grant in this case. That's a motion to continue. And so I would drive them to a trial date, usually had about 10 actual trials out of maybe 30 cases, and then decided them. And many were jury trials. Many of them were prisoner cases where prisoners would sue because they didn't like the conditions in the prison. I had a couple coming out of one of the real tough places in New York. It's still tough, Rikers Island. And they treated people differently than in Fort Madison.
And if the prisoners in Fort Madison, of course, in Fort Madison, there's a new prison down there now, but if they could see it, they might have a little different opinion about their own situation. But that's ended, right? You're no longer going out to Brooklyn.
No, I gave up on that when I moved to Nevada.
Which was, when did you move?
In 2001. Right at the time I went senior. We had purchased a lot in a small town there. I had been going to Nevada to teach at the Judicial College in Reno, and my wife said, "You mean you don't have to live in Iowa just to be a judge in Iowa?" And I said, "Well, that's what they told us at our senior judge conference." She said, "Well, it's time to change." So we did.
Talking about Nevada, you and Kirsten are pretty active.
We're very active outdoors people. She is extremely active. She's been the president of their Trails Association, where they build and get easements across land, and it's a great extensive network of hiking trails, also for biking and horses. We don't do the horse thing, but we have many trails right near us, and she's been the president of that and is very active in that work. We used to be active in gaming, like golf and tennis, but we don't do much of that anymore.
But you're, I think, on the library board of is it the Douglas County Library?
Yeah,
I was very proud I looked that up.
I became one of the members of a 5-person board of the Douglas County Library. It's the greatest library in the state. It really is wonderfully attractive to everybody, especially emphasizing children's books, tapes, and the libraries today, books are secondary. It's all of the videos you can get, movies,
All kinds of media.
and they have set up of computers, and you can get every magazine in a computer format. And I was on that board for 4 years, and then I was appointed chair, and I still am. And it is good to be working with the community. We are actually appointed by the commissioners of the county, and Nevada's government is much different than Iowa's, but that's been my most active non-legal work.
I think Douglas County is just south of, is it Carson City?
It is just south of Carson City, Carson County, and it's composed, about 10% are what we call Nevada-born people, mostly persons who immigrated from California. Taxes are maybe 10% of what they are in California.
But it's
Beautiful country. It's right on the Sierra Mountain Range.
But though you've stopped working in Brooklyn, you've taken some assignments with the Ninth Circuit Court of Appeals.
I have worked with the Ninth Circuit Court of Appeals on 3 separate occasions, 3 judge panels. I have worked with the Federal Circuit in D.C., mostly on patent and administrative cases, and have worked some in the district court in Las Vegas. And that's a different story, too. Nevada is divided into 2 approximately equal political parts. Republicans dominate the North, Democrats dominate the South. Harry Reid, who's been a very active, of course, chair of the, or speaker of the, no, he's been the majority leader in the United States Senate. He's from Las Vegas. But I was asked to work, that's kind of interesting, I was asked to do visiting judge work in Las Vegas to take over the cases, largely criminal cases, that were being handled by a judge that Harry Reid had seen to be appointed to the district court. And I was asked to take over his cases because he decided not to be a district judge anymore in Reno. He ran for, and has been for 6 years, our governor. So Harry Reid saw to the appointment of Governor Sandoval as our district judge, so he wouldn't run against Harry Reid, Sandoval being a very political person. But Harry correctly saw that Sandoval could be elected. He was, and then the person that Harry Reid had seen would be elected suddenly had a lot of cases in Las Vegas to try. So I went down there and tried cases in Las Vegas.
You pitched in. Of course, moving to Las Vegas, that wasn't your first.
Oh, I didn't move to Las Vegas. I was only there. I was only there staying at of course, at a casino,
but you've been out to
was
Nevada
inexpensive.
Plenty of times.
Oh, I've been to
at the National Judicial
but
College.
always Reno, never Las Vegas.
The National Judicial College in Reno is for state judges.
It is all state, or there are some federal administrative judges who go there. And I taught writing skills to judges of all types.
And you did that many times, didn't you?
Yeah, at least
on an annual basis.
Twice a year I would go for a week each time. And I got to know many of the faculty members, and I know that Iowa judges generally have gone to Reno and have gotten good education there.
I did as a state judge, and it's a very good program. But it's used by many states as basically boot camp.
It's their only training in most states. The one state that doesn't use the Judicial College in Reno is the state right next door. California has its own state judicial program.
But I want to ask you about teaching judicial writing. And as in my impression is, and I think I told you this yesterday, is that you can write an opinion and decide a case in 2 or 3 pages when most of us would take 20 or 30. And you're pretty spare and focused. Is that what you teach in Reno?
Say no more than you have to was my basic slogan. And I've always thought brevity was a positive. In a bench trial where you have to recite lengthy facts, that's different. But I don't see any point in citing 30 case citations if 2 are right on the mark. And so I believe in no extended unnecessary writing. And usually a good opinion consists of fewer than 10 pages. Appellate as well as trial court, and I've been disappointed in the U.S. Supreme Court that never got that message.
Well, my solution that I've always thought they should make them use quill pens or something like that. Be shorter.
But I also observe that when I ask for proposed opinions, the lawyers usually want extended length. They want to write lengthy proposed opinions because they don't want to miss anything that the judge might hang its hat on.
They don't know what might stick. But do you find proposed opinions useful?
I do, because I would like always to know what the lawyer would like to see in the printed page if successful. And also, if unsuccessful, that at least it wouldn't have all of the language that would be bad for the client or the group of clients that lawyer represents.
Now, as you mentioned, since taking senior status, you're continuing to serve here in the Southern District of Iowa.
I am.
In all 3 of our courthouses, but you have a pretty large number of cases, I think, both in Davenport and Council Bluffs.
I have had until the last couple of years, and it seems that when Judge Jarvie moved from Davenport for some reason and moved here to Des Moines, I think he still does a lot of Davenport work, but he was doing as much of the Davenport work as he could and took over a couple of my Davenport cases. And it's simpler for me to work on cases here in Des Moines simply because my law clerk, Ann Beneke, who has been with me for, I guess, 20 plus years, works more closely with me in the courtroom when I'm here. I don't require her to travel to Davenport or Council Bluffs.
Ann, I think, has been with you. Didn't you work with her also when you were state?
She was with me when I was on the Supreme Court in 1981 or 82.
But you're still trying civil cases here.
I try as many civil cases as I am allowed.
And you have some set coming up, I think.
I have definitely this week and next week hearings, getting them ready. And in November I'll have one bench trial for sure and one jury trial.
Now, in our district, the magistrate judges, of which I'm one, conduct the final pretrial conferences. And often in your cases, they'll come in and I ask them how long it's going to take to try the case, and they'll say, well, we need 10 days. And I will often say, well, you know, Judge Wolle is your presiding judge, and I may have visited with you before then, and I say, you can have 4 days. Can you get it done? And they seem to do it. But your trial management approach, how do you get people to focus, get it done within a tight time frame?
I have occasionally put time limits on individual witnesses, individual closings, and actually the opening and closing under our local rules are fixed in time. But I just believe lawyers like to know that the judge doesn't want extended comment or extended witnesses that aren't needed. And I think clients pay less money to the lawyers if the trials are shorter. And I don't think the quality is diminished by the absence of length, just my opinion. And is that achieved? Well, Judge Edward McManus, before whom I tried many cases in Sioux City and even Cedar Rapids, he would occasionally say to the lawyer, move on, or anything else, and would not permit any extended time to bring a witness in. So the lawyers had to get everybody ready for the trial and move it. And it made sense to me to try to accomplish that myself. And of course, if the trial lawyers have some experience with that and know that's what the judge insists on, they prepare the case in that way. So a lot of it is reputation.
When I began, I said that the last video that was done of you, which we've taken a second shot at, was in 2003. There's a lot that's happened in our district since 2003. The judge who succeeded you, Judge Gritzner, has taken senior status.
It's just amazing to me that could happen so fast.
Judge Pratt has, of course, taken senior status. We have three new district judges since 2003. Judge Jarvie, who's been here for the better part of 10 years, but Judges Rhodes and Goodgame Ebbinger are relatively new judges. I think we've been through 4 United States attorneys. We're on our 4th or 5th of those. A couple of chief probation officers, by my count. Our 3rd clerk of court. And of course, Judge Viator passed away earlier this year. And as you know, Judge Longstaff, at the end of this month, well, actually a week from today, is going to officially retire from all judicial work on the court after a career in our court which has spanned 50 years.
Fantastic career. Ron Longstaff has been you cannot measure the quality of his work in this court for all these years, starting not as a judge, as a commissioner, and then, I guess, clerk of court, and then as a U.S. magistrate judge, and then district judge, chief judge. He's always been measured well.
He's done it all, truly. And of course, Judge Viator, you spoke of him.
I've always thought
earlier.
he was a judge's judge, and I've described him that way to the Eighth Circuit when he took senior status. And he was a great trial judge in Cedar Rapids before he became a U.S. district judge here.
Well, I know him well also, and I echo your comments 100%. But they were the three judges that you served most with as colleagues on the bench. I think Judge McManus is still active as a senior judge.
I do not know how active. I have seen him a couple times, and he looks healthy.
But Judge O'Brien passed away also in recent memory.
And Judge O'Brien and I had trials against each other as lawyers in Sioux City before he was ever appointed to the bench. And he,
of course, he had, maybe you would agree, but he had a reputation of the kindest people, I think, ever to be a judge. He was very thoughtful, listened to everybody all the time. And I think he had hearings. Let's talk about Social Security cases just for a moment, because it dovetails a little bit with Judge O'Brien. You have a lot of Social Security appeals. I
did a few Social Security cases as a lawyer. I have specialized in Social Security cases here because this district has many, many cases. Bob Pratt himself, when he was a lawyer, had a large clientele of people seeking Social Security relief. And I've never turned them down, and in fact have helped some other judges get involved with them. I've always thought it was inefficient for magistrate judges to do Social Security cases when all they can do is make report and recommendation on the outcome, when, at least in theory and technically, the district judge would then have to do the same review of all the papers. And I've also thought that it was useful for a judge like Judge O'Brien to not just read the entire file, which is a stack of papers, medical reports, and witness testimony, but also to hear the lawyers focus on just what are the key issues. So I've always been benefited by being ready to decide a case, but then hearing the lawyer focus on exactly what should be done in that case. And the assistant U.S. attorneys have been very cooperative in responding orally to the oral arguments of the claimant's attorneys. To the extent I have much knowledge of it, and I haven't handled many Social Security appeals myself, but holding hearings is not often done with many other judges. But you find them helpful? I find them helpful, and I regret they aren't often done, because I have great respect for lawyers in all their capacities, and I want to know not just what somebody said on the record, but I want to hear the lawyer make an eloquent argument for the client. And I saw Don O'Brien actually interrogate Social Security claimants because he wanted to get to see and know how this person has or has not a compensable disability. I don't know that most lawyers know this, but different from state court, which gets state district courts, and particularly here in Polk County, get administrative appeals from all kinds of state agencies come to them under the Administrative Procedure Act. But on the federal side,
Our administrative appeals are pretty much, not exclusively, but pretty much consist of Social Security appeals where somebody's been denied benefits.
Well, and they can come from other federal agencies. I've had some in New York as well as here in Iowa. Some involving the laws governing water use. I noticed that this district's going to have a very large case involving the question whether or not farmers are contaminating the water that is used in the drinking sources. But administrative reviews generally are done on the record and not by oral presentations.
Over the years, and particularly recently, the number of civil case filings in federal court have declined, and they do continue to decline, and with that, a decline in the number of trials.
And is that nationwide as well as in Iowa?
I think it's nationwide, but it's particularly, I think it's a phenomenon that's much broader than Iowa, but it's certainly true in our district. And I wonder if you have any opinions as to why that is, and is it good or bad?
Well, first, I wish it were not a decline, because I think lawyers and their clients get the best sense of value of a claim before trial on the basis of how it's been, what have been the outcomes after trials. So, and I know there are books that contain evaluations of cases of different types. I really think it's important to know currently what types of cases are worth. That's why we did the whole asbestos project. Why are cases not tried as often as used to be the case? And I know that is a decline. I think it's too expensive for the clients. Maybe it's because clients have a better sense of the value of the case and therefore can settle. But I do think we need trials in order to value truthfully what jurors would do in a case. And the same with the criminal law. If not all trials end in convictions, more charged persons would go to trial.
With the fewer trials, of course, that means fewer people, lawyers get into federal court to actually try cases. Do you have any impression as to how that affects the legal profession, particularly if that would also be the case in state court, which I don't know?
Well, it depends a lot on the manner in which cases are being administered in the courts. And I think in the U.S. District Court for the Southern District of Iowa, we are encouraging trials. We streamlined the system for getting to trial, and you don't have to wait years and years to have the trial happen. It may be that pressing cases forward to trial puts unnecessary and difficult pressure on the lawyers to achieve settlements. I don't know. It used to be the rule of thumb was the busy lawyers, the good lawyers, the trial lawyers, the real great lawyers were too busy to get to trial all the time. That doesn't make any sense. But there certainly are many trial lawyers who want to go to trial and are too busy. I don't think that happens here. I think if a trial lawyer on one side, a couple of lawyers on the defense side want to go to trial, they'll get a trial date as soon as they want it.
We don't have trailing dockets anymore. Remember those?
I've always worked on a trailing docket and still do, in that I have trials set in the months of January, April, June, November. Those are the months when there are a number of trials ready for the courtroom, and usually 3 or 4 in each of those months. Some settle, not all, and then in the final pretrial conference, usually before a magistrate judge like yourself, the magistrate judge will give specific dates for the trials to start.
You know, we have electronic files now, and electronic filing. And how pleased were you to see that development?
I was not pleased, because I like to read paper and I don't like to read a screen, and I don't like to fuss around with a computer trying to find just what I'm looking for when the important papers are in front of me. And I print out the critical case filings and the briefs and the pleadings in any case when I sit in the courtroom, so I can read the papers and not have to look at the screen. Even though there are computers set up, screens set up on each bench in the Southern District, I don't ever look at them. And so I'm not happy with that, but that's just because I'm old-fashioned.
I've gotten used to it, but I can't do research on the screen. I have to have books. But
something about the heft of a book that helps.
I agree. And plus you can turn back and forth easily, which you can't do on the screen. But I digress. You have been a lawyer for 55 years. And you've served as both a trial lawyer and as an appellate lawyer over that period of time. And of course, many, many years in our court, and are still serving as a judge.
And even a teacher of judges. That's what I'm particularly proud of. Nobody has said I did a bad job.
I wish I'd have had the writing course from you.
I've saved trees by cutting down on the length of judges' opinions.
I've never got it on the short opinions, but that's just my problem. But as you look back, we're all this long time, and it is a long time. Would you do anything differently?
I would repeat all of my good times and bad times. I would hope I would have played first-string basketball each of the 3 years I was eligible to play for Harvard. I wish that I had had more actual in-court trials as a lawyer in Sioux City. I had a lot. I was a member of the a fellow of the American College of Trial Lawyers because I was quite active. I think you had to have 15 trials a year or something like that. And there were cases that ended up settled that I really recommended against settlement, but my client said, no, I don't want to take the chance. So I guess the bottom line is, if I had it to do over, I'd be more aggressive in being a lawyer as well as in being a judge.
A lot has changed in 55 years, too, about the practice of law, how courts operate, how we operate here. And, of course, a lot of different people are now going forward with the kinds of things we used to do. Are you optimistic about the future of the courts and the legal profession?
I am optimistic in a general way, but I think there are ways that the future is moving into areas that may punish quality of justice. For instance, too many settlements do not achieve justice. And I wish there were fewer settlements and more trials. And that's just because in my experience, most of the cases that actually went to verdict or to judge's decision were correctly decided. So I don't think people make a mistake by going to trial. Would I change the system? Yes. One thing I have long advocated is firm settlement deadlines. Cases that settle a day or two before trials to start, that doesn't make any sense. The case should be prepared for trial in the last week before trial, not settled in the last week before trial. And I fear that sometimes, and I've experienced this happening usually on the other side of the case, although perhaps in my case, clients don't really understand why there should be a settlement until the last minute, and then they get nervous. And that's because the lawyer hasn't early disclosed to them why a settlement would be beneficial and why the case should be prepared for trial. There's no point in spending a lot of money preparing for trial if you're going to settle.
I always set settlement deadlines, but I have found that if a case settles after the deadline, it's very hard to be angry with the lawyers for settling a case. And sometimes, as Judge Hanson used to say, sometimes it takes a while for reasonable minds to function. But I agree with you. I think settlement deadlines can be useful for the lawyer in dealing with the client to kind of bring things to a head.
Yes. Clients don't understand the risks. They always understand the benefits because they went to this lawyer because the lawyer said, you'll win $1 million. And so then when the lawyer says, let's settle for $50, the client says, didn't you say it's $1 million? He said, well, I've learned a lot more since then. But I fear that it's a matter of communication between lawyers and clients frequently. The lawyers might be able to settle a case, but the clients don't come to the need to settle until late. And that's too bad. It's a matter of education.
Well, I'm kind of the end of my notes, but before we end, is there anything else that you'd like to add before we conclude?
I would like to ask you the same questions you've asked me, and you had a great reputation as a trial lawyer and judge in Polk County. What would you say is the reason so many cases that look like they're trial ready then settle?
I think the honest answer is we've gotten to the point with our process, particularly in federal court, that we get many summary judgment motions, and I have a feeling that many cases lawyers target that as the breaking point as to what they're going to do, and if the summary judgment is not granted, then we tend to see settlements emerge. Now, there may be good reasons for that, but I think by then the expenses has kicked in. There's greater risk, frankly, than in what I used to be called as the old days when you try insurance cases and $4,000 or $5,000 would be a big verdict. I mean, there's sometimes more at stake, and I think my personal feeling is, since you asked me the question, is the process to get to the jury room has become encrusted over time with a lot of motion practice, a lot of discovery, a lot of things that lawyers think they have to do in order to get a case ready for trial, and there's an inertia that develops within a case, and sometimes they just run out of gas sometimes.
Is there too much discovery? Does the use of frequent depositions in each case detailed proposed interrogatories, written interrogatories, exchange of information, exchange of all the electronic data. Does that really give the lawyers better idea of what to recommend as a fair settlement amount?
Well, it's hard for me to answer that question. We as judges have ideas about that, but unlike the other two people in the room who are practicing trial lawyers, they have a better idea what they need in a case, and I think the needs have changed over time. It's kind of like up in the field of dreams. If you build this system we have, they will come. If you set deadlines for Daubert motions, they will come. And so we create a structure that encourages a lot of stuff. Does it help us as judges? Do we see? How many times have you seen an interrogatory answer be the seminal thing in a case that you can tell? It just locks it up one way or the other.
Well, I never know what triggered the final settlement, but at trial I never see the discovery exchanges that made the difference in the case. I think in most cases the lawyers know pretty much what the trial will look like before they ever get into the discovery, and there are very few hidden smoking guns.
But we see it when when the curtain goes up and the lights are on, and the people have put together what they put together. And so when I give opinions on this, I'm always aware that a lot has gone on in the hurly-burly of being a practicing trial lawyer these days that we don't see. But I do think as the civil justice system has developed, it has developed in a way which makes it awfully tough to unless the lawyers want to do it, unless they're working together and have a common goal to get there. It makes it, there's a lot often, in many cases, to get to the...
And I fear that many times lawyers on the defense side in particular achieve greater profits by having extended discovery proceedings.
Well, you never know. I think clients and insurance companies maybe push back against that. And that's part of the tough thing of being a lawyer, either on the plaintiff's or defense side, because there's a cost, and that's always a factor, I think, in what people do. But
well, unfortunately, in my case, it's been 30-plus years since I was an active trial lawyer. Let's say from 1980 to today is 35, 36 years. I've been out of that arena so long, except to see the outcomes of their lawyers' work. I don't know what it would be like to be practicing law as a trial lawyer today.
Well, I think you hit on it, because I think the ultimate question is the outcome of the process, achieving fairness, resolving disputes in a way that people can be satisfied with. That does involve issues of cost and other things like that, but
well, let me put it this way. My bottom line is I believe that people who hire lawyers and actually go to trial and see the outcome of the trial are more satisfied with the judicial system than those who are pressed into a settlement by their lawyer.
I'm sure that's often the case.
Too many lawyers take cases without really being prepared to prepare and present the case beautifully.
Well, we'll let that be the the last.
And too many judges encourage settlement.
Well, there's a really, to me, a philosophical thing there about encouraging settlement, because I do a lot of settlement conferences.
Of course.
And
I ask you to.
Yes, in fact, just the other day.
Because I don't want the case settled once it's ready to begin.
Yeah.
I don't want to have to do the work to get ready if the parties don't really want a trial.
The thing about judges encouraging settlements, and settlements are a good thing because most cases should be resolved. The parties ought to be able to resolve them in an honest and fair way. But by pushing settlements or being involved in settlement conferences and things like that, one way cases settle is I get worried when the judge says you ought to settle because the outcome may not, our process is one that you can't predict or rely on to reach a just result. Now, I never say that, but I'm afraid sometimes that that's what they may be thinking when a judge tells you you should settle. So I've always had a little bit of conflict about that myself. But settlement conferences and mediations are part of our legal culture today. And I don't know if it's a good or bad thing, but it's there. And as I say, I think the outcomes,
Well, we seek rough justice, and in settlements we get rough justice. In trials we get clear-cut wins or losses.
That's true. Once you get by the post-trial motions and the appeal. That's the thing is, as I repeat, there's so many hurdles to get to finality that the system kind of operates against itself sometimes. But that's you asked me a question, and now I've said too much.
And now we have had the preface to this real live show. So let's start.
Well, I think we should conclude. But
Thank you very much, Mark. Thank you, Dick.
It's been great fun for me.
And we talk on and on and on, don't we?